Good afternoon. This is Naif Mubarak in Orlando, Florida. It is Thursday, June 10th, 2021. We normally do our Facebook Live at 6:30 p.m., but there is an event for the American Immigration Lawyers Association, and I didn't want to miss providing you guys with a really important update, so we decided to do our live today a little bit early. So we'll just wait a few more seconds, and I even prepared a presentation for you. This way it'll be easier for you to watch later today or with anybody who you believe would benefit from this. Okay, so we're doing the Facebook Live early and we didn't reschedule because, again, this is important news. And so the news is relating to immigration law. On May 27th, 2021, an ICE memo, Immigration Custom Enforcement, was issued regarding what's called prosecutorial discretion and in basically enforcement and removal priorities. So for those people who are in court process, for those people who are going through the system, this is a really important update for you, and you'll see why in just a few moments. Hey, Othman, good afternoon to you. Happy belated birthday to you. Thanks for joining us. And so now what I'm going to do is just remind everybody, if you can, to contact us if you have any questions, and follow us on social media at Mubarak Law if you can. And now we have another person, Lana. Good morning, good afternoon. Thank you for joining. And we are going to go ahead and get started with our presentation. So let me see. Okay. Can you see the PowerPoint? All right. Here it is. So this is the memo OPLA Immigration Court issued on May 27th, 2021. I've never done this before, so I'm going to ask Jessica if she can see me. Can you see me?
I can see you.
Okay. I can only see the presentation. All right. So what is in this memo and why is it so important? Basically, during the President Obama's era, there was something called prosecutorial discretion, which allowed immigration attorneys and people in removal proceedings to try to get a better outcome based on reason or circumstances with the OPLA attorneys. Now, the OPLA attorneys are the attorneys for the removal proceedings. They're part of the government. They're the ones who typically try a case in the immigration court removal or deportation proceedings. So now, during the Trump administration, prosecutorial discretion went away and everybody was treated the same. So currently, if you were, somebody who's been here for 30 years and you have a minor criminal case or you've been out of status, you're going to be treated the same as somebody with multiple criminal convictions. They didn't have the ability to give discretion and to make reasonable decisions. So what we're going to do is go through what the memo states. It's actually a very lengthy memo. It's one of the longer, more detailed ones I've seen. And that's why I wanted to put this presentation for you together. If you have any questions, let me know. So there's something called enforcement and removal priorities. So before we talk about immigration court, let's talk about those who might be apprehended at the border or here in the United States without status. Are they an enforcement and a removal priority? So this is what the government wants agents or OPLA attorneys to consider when they're deciding whether or not to enforce removal or not. So national security is basically any non-citizen who engages in or is suspected of engaging in terrorism or espionage, or whose arrest would result in protection of national security. So this is saying if somebody is a threat to national security, then obviously they should not be given PD or prosecutorial discretion. Border security. This is, as it sounds, right at the border. Non-citizens who are apprehended at the border, at the port of entry while attempting to unlawfully enter the United States on or after November 1st, 2020, you will be considered an enforcement priority. So if you cross the border December 1st, 2020, and then you're arrested, you are a priority in this case. And for those who were not physically present in the United States before November 1st, 2020. There's a typo in here, but don't mind me. We just put this together for you a few minutes ago. Public safety. So we want to make sure that if we're going to give discretion to somebody, they are not going to be a threat to public safety. And this gives you some examples. Non-citizens who have been convicted of an aggravated felony defined under the Immigration Act, you're going to be considered a threat to public safety. Or if you are involved with street gang activity or any criminal organization, you're considered a threat to public safety. So they want to make sure these are the people they're going to focus on when it comes to detention, when it comes to prosecuting removal, and when it comes to enforcing the immigration laws. This is going to be the agency's priorities. So if not enforcement priority, these are some considerations. If you do not meet in a priority, this is what the benefits are. This is the good news that I wanted to go over with you guys. So first thing here is deciding whether or not to issue or assume custody of a non-citizen. So if somebody is apprehended by an ICE agent, they can now make the decision, do they need to put them in an immigration jail, or can they be released on their own? Can they be released on a bond without going through the immigration court? So this is a really important factor, because if you have a family who was apprehended, instead of them being separated and incarcerated, this may allow for an ICE agent to apply discretion and to not take them into custody or to issue a detainer. Number 2 here says deciding whether to issue or serve, file, or cancel a notice to appear. What is a notice to appear? Notice to appear are essentially like the charges an individual faces when they are going to commence removal or deportation proceedings. Okay, so the notice to appear will say, you were born in Colombia. You are not a citizen of the United States. You entered the US on this date and you have a tourist visa. You have overstayed your welcome, overstayed your visa. And now we are charging you as somebody currently present in the United States without status, and we're gonna put you in removal proceedings. So these are like the charges. So deciding whether or not to issue one, to file it or cancel it, is now going to be a discretionary decision for these OPLA attorneys. So let's say you have an individual who's married to an American citizen. They're waiting to get the money together to file for their paperwork, but then they have an encounter with ICE. If the NTA gets filed with the immigration court, then this is going to delay their process for years, because USCIS will lose jurisdiction, lose the ability to grant the green card because this NTA was filed with the immigration court. So this will allow us to make an argument with or to make a proposal with the OPLA attorneys on whether or not they should file or cancel the NTA to begin with. So again, this is good news. Number 3 says deciding whether to stop, question, or arrest a non-citizen. So again, the ICE agents encountering, they can make the decision to arrest a non-citizen based on the enforcement priority factors. And then the release from custody, number 4, I talked about that a little bit earlier. Number 1, we were talking about detainers. So, usually a detainer is issued if they want to take them into custody. And then number 5, deciding whether to settle, oppose, join a motion, or dispute. Basically giving OPLA attorneys the ability to kind of give some discretion and give some wiggle room, where prior to this, they were required to prosecute every case as if it was the same. So what does this mean for OPLA attorneys, and what does this mean for people with pending immigration court cases? First and foremost, let me say, if you're one of our clients, we're going to contact you next week. If you're in removal proceedings, if you're in the immigration court, we're waiting for additional information to come out, see how it's going to affect all of you. But we have already made a list of individuals who we believe that this memo is going to be of assistance for. So please be patient and be on the lookout for an email from our office regarding this memo by sometime next week. Okay, so again, we mentioned should a notice to appear be issued? That's number one. We talked about that. Should charges be issued? Can they cancel it? So that's going to be the discretion also now for the OPLA attorneys. Number two, this is a little bit legally complicated, so I'm going to explain it. Administrative closure used to be a tool we would use to allow us to remove the case from the judge's docket, in essence, or in a way, to put the case on hold until a later date based on some, discretionary factors, if there was children, if somebody was sick. During the Trump administration, the Attorney General issued some case law that prevented immigration judges today in many jurisdictions to close cases. So this is still the same. Administrative closure is not back yet in every jurisdiction. In some jurisdictions it is. In Florida, it's not. And then continuances. So now they're saying you can use discretion to continue a case if you need more time, if there's a real compelling factor as to why somebody deserves a continuance. The OPLA attorneys will now have the ability to make that decision. And they're also going to go back and look at the enforcement priorities that I discussed earlier, those three things, as to whether or not somebody would be deserving of a continuance. So number three, this is very good, it says dismissal of proceedings. There are over 1 million immigration court cases right now that are on years of backlog. Some of these cases are probably going to be granted. Some of them is what we call a no-brainer and a waste of government efficiency and time. So this is allowing OPLA attorneys and the attorneys for the immigration clients, the respondents, to file motions to dismiss if they're going to join us with this. And we're going to talk about this on the other slide because there's more details on this. And that's really the one I'm hoping is going to benefit many of our clients. Okay, so number three, we're going to come back to. So really quick, more information on this memo. Number four says pursuing appeals, bonds, and responding to inquiries. So pursuing appeals, let's say we're in immigration court and we won, we stopped, we canceled the removal proceedings for our client. Normally, the government would have the right to appeal. And during the last 4 years, they were pretty much required to always keep their right for appeal. But now this is saying that they'll have the ability to waive their appeal, to not pursue, so that our clients could then know that this decision is final. And bonds, again, they can join us on bonds. And this responding to inquiries I felt like was interesting. So they said that they're going to set up an email box or so that we may be able to have communication with the courts and with the other side again, which has been lacking severely for several years. Again, the last thing here, joint motions to reopen, motions for relief, and stipulations. A joint motion to reopen is usually filed when somebody has already been deported or has an outstanding removal order or deportation order. And oftentimes, this person's situation has changed, and we want to file a joint motion to reopen and basically remove the deportation or removal order from their file. And by opening proceedings, it may allow them to correct their status. We typically need an OPLA attorney to join us on many of these motions to allow our clients relief. Now, we have Palestinian clients or stateless individuals who have outstanding orders of removal who for 20 years have been married to a citizen. This may be beneficial to help us reopen their case so that way we can pursue a green card. And then stipulations. This basically means that we can make an agreement with the other side, with the government attorney, as to which factors are disputed or agreed to or stipulated to. So for example, in an immigration court case, sometimes there's several factors that you have to prove. Did the person enter this marriage in good faith? Was it real? Was there abuse? So if, we know the marriage was real and there was good faith, myself and the government attorney can agree on these points and we can just focus on the last part, right? So that's what the stipulations mean. It's allowing the government to stipulate and agree to certain requirements if it's clearly demonstrated. A lot of times it doesn't make sense to spend hours arguing over something that we know is already true. So I'm going to come back and talk about number 3 for dismissal of proceedings, because it has its own factors that they're going to look into when it comes to deciding if a dismissal of proceedings is warranted. Okay. Dismissal of proceedings factors. They want to look at, does your client have any of these things? Is this way we can get some discretionary factors looked at by OPLA to see if they will agree with us that it is warranted to dismiss the removal proceedings, to dismiss the deportation case against our clients. So for those people who are military service members or immediate relatives of military service members, this is, a good check in a good point, basically, on your scale as to whether or not you might be qualified for dismissal of proceedings. Individuals likely to be granted relief. What does this mean? If you remember earlier in the presentation, I mentioned to you that perhaps there was somebody married to a U.S. citizen, they have a child. Besides the fact that they don't have the money to pay for the government fees, he would apply. So that's what's called relief. What is the likelihood that this person is going to win their case? So if we have a strong case where we know that a case is going to be approved, it doesn't make sense to keep it on the court's docket. So we want to agree to dismiss the proceedings so the person can then complete the legal process instead of waiting years, delaying the courts, and all sorts of resources. Long-term lawful permanent residence. For those of you who don't know, you should know, even if you have a green card, you can still be deported or removed if you abandon your residency, if you get convicted of certain crimes. But if you've been a resident, especially for those who've been residents since they were children, for a long period of time, this is a positive factor in your case where hopefully the government is going to agree to dismiss it, because more likely than not, you would probably win your LPR, cancellation of removal, if you were eligible. So significant law enforcement or government interest. What does this mean? This is basically if somebody in removal proceedings or deportation proceedings is a witness to a crime, or they're prosecuting a prosecuting witness, or they're what's called a CI, a confidential informant, it may be in the government's interest to not try to remove this person when we are using their information and their knowledge to help, investigate or prosecute a larger crime. Finally, there's compelling humanitarian factors. And if you remember a few minutes ago, I said, the last 4 years, every removal proceedings case was technically supposed to be treated the same, whether you're a criminal, whether or not, whether you have 5 kids or 0 kids. But these humanitarian factors are back, thankfully. So if somebody is very old or very sick, or he's a caregiver for the children who's also sick, these compelling humanitarian factors are going to be considered in whether or not we dismiss proceedings. Okay, so that is basically the presentation for you guys today, and I know that was a lot of information. It was an incredible amount of information, and that's why we put it on a PowerPoint for you all to see it, and so you can share it and somebody else can watch it later on, and we're happy to answer questions. Some things we're not sure about is how are work permits going to be treated in this case. So it's great to have your court case dismissed, but how is that going to affect somebody to have a work permit or a right to live here? So I do have a question. It says, good morning, I'm from New Jersey. Is the new Biden administration planning to give temporary status for undocumented frontline workers? I haven't seen anything like that come down the pipeline. I know that has been suggested, but for right now, I haven't seen that, anytime soon. Typically, a temporary protected status usually comes for certain countries of, who are facing strife or political turmoil. But I know that this is in the middle of the day and not our normal time, but I felt like it was important. We're going to have this memo and the presentation on our website. So feel free to check out our social media and share this video later with your friends and family. This way they can educate themselves if anybody you know is going through removal proceedings or has been apprehended by ICE. My name is Naif Mubarak with Mubarak Law. Thank you for joining me, and I will see you guys next time.